OKFM 101.7.
Na I counsel mami musa we so yewura Gyekye Quayson.
Yes sir.
Me hu ni yi bia wono so afile na ewo ha me pesenka ye ne udi nkomo na agya ubie nani so baako de ekire yen so far me hu na David be in support of what's it about I mean kinda imuna ho affidavit in support of the case of first defendant. Aha. Na watchotwo ni nyina de aba ni issue no but you say follow kakra. Endo amete say ekoi ne kosi say. Okay. Now what do you make of sa niamanema ekoso yi?
You brother me say wa woni say this Gyekye Quayson Assin media idea I can say I travel almost getting to 2 years now. Immediately after the 2020 election, Mrekwa Electoral Commission declared as the winner of the parliamentary election, and Assin of MPP Central Regional Secretary. I friend and or file a petition at the High Court in Cape Coast. Among other things, all alleges Honorable Gyekye Quayson in the 1970s, or Canada, acquired Canadian citizenship, and by reason of that, only qualified by reason of Article 94, 2A of the 1992 Constitution. Same way by or did the FN injunction application. So because why issue petition at the court ma Gyekye Quayson for him to be sworn in as the duly elected MP for the people of Assin of. Into share Assembly by lawyers for Gyekye Quayson Ekasu Nankebe even before the hearing of the injunction application and during the hearing Omokasi Nankebe Judge na Udi Assembly at Cape Coast High Court because Article 94 2A receive any interpretation from the court on stay in the proceedings now on call Article 132 of the 1992 Constitutional Ekase in the course of any proceedings, if an issue of interpretation arises, the judge or the court must stay proceedings and refer the matter to the Supreme Court. So same way, Emra Ebayeno, lawyers for Nimfa, our petitioner, Ekazu, there's no need for the referral to the Supreme Court because Supreme Court had decided matter was an autocratic. So there's no longer the need for interpretation. Obiansu says the constitutional provision now Supreme Court interprets in Senator different from Article 94 2A. So that was the contention at the High Court. Judge said, "Oni petitioners are lawyer for the judge and said there's no need for interpretation and the matter is clear and ambiguous, no or so or granting injunction against him or kaya." In that substantive matter, no, and so one process you will be a friend of setting down the issues for trial. So at the setting down the issues for trial,
let's just say and summer yen na be gia tum say we and I
judge no so onhwe
one way
into hono in our lawyers for Quayson can say, my lord, at the core of this matter is Article 94 2E. Into still proceedings now refer at the court. So Supreme Court the Obeka Biano. It binds all lower courts. Again, lawyers for petitioner, any judge may say, Omone, Gyekye Quayson a lawyer for Enyadri. So, or settle down the issues. July, make a judgment declaring the seat vacant. So, okay.
That was in July, yeah.
In July 2021.
Mm-hmm.
Nti eba na Gyekye Quayson said no, on any Enyadri, file a notice of appeal. Or filing notice of appeal, no, and I also applied the FNO stay of execution at the count. Into a 7 court of appeal, no, and lawyer certificate file a motion for leave, so be file additional grounds of appeal. And I always constitutional interpretative matters. And what kind so now yeah. Court of Appeal and stay the proceedings. Non-refer Assin Supreme Court. Again, lawyers for petitioner no. Ejina Muka say provision is clear. And here any interpretation view into yanko straight away. Na Court of Appeal and yeah. Mr. Chikata can say that be. Article 132 of the 1992 Constitution is mandatory. Yeah, can say the constitutional provision 94(2)(a) say you should owe allegiance to no other country other than Ghana, not necessarily a dual national. No, there are ambiguities. Into a sermon, an idiom. Moon stay among the non court Supreme Court. Court of Appeal say that be Yadrin one. Lawyers for petitioner and so can say Yadrin our interpretation or the Court of Appeal can decide the matter. And also into a basano, Mr. Chikata file certiorari application. Apply for stay of the Court of Appeal, the Omoye Ohono, and now or this is and a bar Supreme Court. Now, interestingly, no, and now or the way in bar Court of Appeal, that Supreme Court for certiorari and stay, no, and Chebiana, the same petitioner, no, or High Court, no. Some could do Court of Appeal. That same petitioner now I issue a fresh writ at the Supreme Court asking for interpretation. I'm saying, High Court, what's a provision is clear when the judge no agree. Court of Appeal, what's a provision is clear when the judge. It is a Siawaba Supreme Court seeking for interpretation of Article 94. 2A, no. If you claim that the provision is clear, why are you in the Supreme Court for interpretation? Into now and the back and forth. Into finally, this writ, I was seeking interpretation of 94, no. And now all the injunction at the atoso, an injunction application at the atoso. Say, before Supreme Court Ebetie Asem Nankasano, Omo injuncted the MP from holding himself out as the MP for Assin North. Into Oshaya, the issue of service by back and forth. Into no, in the Supreme Court, he should be served by substitution through newspapers and among other things. Into the last time I called court, I can't say, on filing a response to the application for injunction, and not run a lawyer for a file at the registry of the Supreme Court. Omar raising a lot of issues. And Supreme Court about this application for injunction. Into Brown Kwame. And Pempensua, you do na, and then they say, and Supreme Court ebetie the injunction application. Now we are where the Supreme Court feels say the verdict or the ruling will go, no, they will give. As to where and then no, you can't tell.
Actually, some ruling on the.
You can't tell.
That injunction application.
Argument now, almighty, and then you know. If you remember a day for a ruling, if you also just then they can rise into chambers and come back with their ruling. And so you can never tell whether the ruling will be today or tomorrow.
Oh, okay. And now affidavit in support of the case of
the. Say one will say when you file injunction, you do an affidavit in support.
In support,
the opponent also bet me the an affidavit in opposition.
Yes.
It's Gyekye Quayson affidavit in opposition. And all can once a man or more file.
Wama exhibit Sahudo exhibit G exhibit.
In fact, Oshe, what taking the court through everything that happened at the High Court.
Exhibit J. Exhibit everything.
Yeah. So our High Court were now how consistently almost this matter be brought to the Supreme Court and they were opposing it. Into a affidavit in opposition, almost can say the petition plaintiff, no current plaintiff, and say, or forum shopping. Bullet 338 in was say the plaintiff ought not to be allowed in forum shopping and sheer manipulation of judicial process to turn justice on its head. Then 39, no, wherefore. Swear to this affidavit in verification of the statement of case filed on behalf of the first defendant in this suit. Okay. So effectively, now so what the courts. Okoha no akoha. Okoha no akoha. Forum shopping.
And no, court to one kokuni.
And you know, a lawyer for more fair no abuse of court process.
Okay.
Which is one of the grounds are omorila. And then I sure say the arguments will be put before the Supreme Court, the judges of our Supreme Court. At the end of the day, the Omekano will take it out from there. The law is in their bosom.
The law is in their bosom. Law, medals are pay.
Okay,
I'm paying some medals.
Best as a lawyer got very Tamakloe and I check on okay 101.7. Maybe I'm
okayfm 101.7.